Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with the Labor Attorney Jung Bong-soo, we will discuss about the Labor Standard Act, Article 49, which is the statute of limitation or prescription of wages. So, could you define the terminology, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I'd like to talk about the statute of the prescription or limitation. So it is designed to protect some workers or employees the right, maybe like wages delayed or so unpaid, then it is hard to know how long they can retroactively apply for the unpaid wages. So by law, to make sure the retroactive the amount it can be applicable to the past 30 years. So when the past year has been passed by, then the employee cannot claim anymore. So this one, it was made to make sure of the employee's claim, how long they can claim, so they can claim up to the past 30 years. So we call it the statute of the limitation. So yeah, I think this one basically, if this is confirmed as unpaid wage, then in civil court they accept the unpaid wage up to the 30 years. But the relating to the punishment of this labor law violation, then it can be applicable to 5 years. So a statute of limitation for prosecution is about 5 years. Yeah.
I see. So this is applied to the employer who do not pay wages to the employee. So the employee can claim for 3 years, within 3 years,
yeah,
about
that's right.
unpaid wages. So this is a very strict rule, and unless the employer follow the rules, he will be punished and prosecuted. Very strong rules.
Yeah. So unpaid wage is a kind of slave labor. So Labor Standard Act regulate very severe punishment for those who violate this the delayed payment. So I think statutes of limitation is the period they can claim retroactively to the past. So if they neglect this their claim, then time passed by more than 30 years, they cannot claim. But for the statutes of limitation for prosecution, it goes back to 5 years. So I think the employee can claim their unpaid wage up to 5 years using this statute of limitation for prosecution. Then the employee's perspective, they have to pay back, or they paid their unpaid wage because if they don't want to be punished. So there are two differences. Like by civil law, the statute of limitation is 3 years, but for the criminal charge, it goes back to 5 years. Yeah, it is different. Yeah.
I see. So could you think of and introduce some good example where Gangnam Labor Law Firm has advised a client and made a successful result?
Yes, there is one very typical case regarding statutes of limitation. So Gyeonggi Province Council, so those lawmakers in the province, they inspect, they audit the administration's activities once every year. So this Gyeonggi Province Council, they hired special the temporary workers so that they could audit those the Gyeonggi province the operations. So in that case, they hired 40 people for 1 month period. So in that case, they just paid only daily pay without additional pay for weekly holiday allowance or monthly the leave. So then one of those employee submit the petition for loss payment for their salary. So in this case, the labor inspector make a decision that the Gyeonggi Province Council must pay retroactively the amount they haven't paid, like the weekly holiday allowance or monthly leave. So in that case, this is not one person's case, because the other workers who once worked there never received any the allowances for weekly holiday allowance or the monthly leave. So Gyeonggi the province council, in order not to be punished, so they had to pay back the 5 years period for loss paid salary. So I think this 5 years period is related to the statutes of limitation for prosecution. So this is very important, how long they can pay back for the violated amount. Yeah.
I see. Thank you very much for your detailed explanation, and it's very important article for both employer and employee.
Okay, thank you for watching. Bye bye.